If you're a green card holder or planning to become one, you need to hear this urgent update right now. There's been massive confusion spreading online about travel restrictions in 2026, and I'm witnessing panic rippling through immigrant communities based on incomplete or misleading information that's causing unnecessary fear and disruption. In the next few minutes, I'll deliver the verified facts straight from official White House and Department of Homeland Security sources about what's truly happening with immigration policy at this moment, helping you separate truth from rumor and make informed decisions for your future. Welcome to US Visa Info, your trusted source for accurate and verified immigration updates. I'm here to provide you with reliable information during a time when rumors and misinformation are spreading like wildfire across social media and community groups. Today, we're tackling one of the most pressing concerns I've heard from our viewers, the claims about a supposed freeze on green card holder travel that's been causing so much alarm. Let's dive right in with the most critical fact up front. Green card holders are not subject to any travel freeze. I'll repeat that clearly because this is absolutely crucial information that can ease a lot of worries. If you are a lawful permanent resident of the United States, you are explicitly exempted from the travel restrictions that took effect on January 1st, 2026. This exemption is not some vague loophole. It's directly stated in official proclamations and has been confirmed by multiple government agencies, ensuring that your status as a permanent resident protects your right to travel and return home without hindrance from these new measures. However, it's essential to acknowledge that there are indeed significant new immigration policies that have come into effect, and understanding them fully is vital for anyone in the immigrant community. These policies can seem overwhelming at first glance, but by breaking them down step by step, we can clarify what they actually entail and who they impact. Let's walk through precisely what the White House announced, what official sources have confirmed, and what this all means for various categories of immigrants and visa applicants. Starting with the core announcement, on December 16, 2025, President Trump issued Presidential Proclamation 10998, titled, "Restricting and Limiting the Entry of Foreign Nationals to Protect the Security of the United States," as detailed on the White House website. This proclamation officially took effect at 12:01 a.m. Eastern Standard Time on January 1st, 2026, marking a substantial expansion of immigration restrictions that builds on previous measures. But it's crucial to grasp exactly what this proclamation does and, equally important, what it doesn't do, to avoid falling into the trap of misinformation that's been circulating widely. This new proclamation restricts entry into the United States by nationals of 39 specific countries, in addition to individuals traveling on Palestinian Authority-issued travel documents, according to details from Congress.gov. This represents more than a doubling of the number of countries affected by an earlier travel ban that was issued in June 2025, which initially targeted certain nations amid COVID-19 concerns, but has now been broadened significantly. The proclamation establishes two distinct categories of restrictions to make the policy more targeted yet comprehensive. First, there are full entry restrictions imposed on 19 countries, meaning that nationals from these nations are barred from both immigrant and non-immigrant visa issuance entirely. These countries include Afghanistan, Burkina Faso, Burma, Chad, Republic of the Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Laos, Libya, Mali, Niger, Sierra Leone, Somalia, South Sudan, Sudan, Syria, and Yemen, along with those using Palestinian Authority documents. This full suspension aims to prevent entry under any visa category, reflecting a stringent approach to national security as outlined in the official text. Second, there are partial entry restrictions that affect an additional 20 countries. For these nations, the restrictions specifically suspend immigrant visa issuance and certain categories of non-immigrant visas, particularly B1 and B2 visas for temporary visitors, F and M visas for students, and J visas for exchange visitors. This partial approach allows some limited entries but curtails others, focusing on reducing inflows in specific areas deemed higher risk. To be very precise about who is actually affected, the travel ban applies solely to nationals of these impacted countries who were outside the United States on January 1, 2026, and who do not hold a valid visa as of that date, per PTOIC law guidelines. Importantly, if you already possessed a valid visa before January 1, 2026, that visa has not been revoked in any way. No visas issued prior to 12:01 a.m. EST on that date have been or will be revoked pursuant to this proclamation, as confirmed by the U.S. Department of State. This means you can continue to use your existing valid visa for travel without fear of sudden invalidation, providing a layer of stability for those who planned ahead. Now, turning to the critical exemptions, particularly for green card holders, which is a topic that's generated so much concern in our community. U.S. lawful permanent residents, or green card holders, are explicitly exempt from both the full and partial restrictions, regardless of their nationality, and they can continue to travel and re-enter the United States freely, as stated on Visa Verge resources. Let me emphasize this point with absolute clarity. If you hold a valid green card, you can travel outside the United States and return, even if you are a national of one of the 39 restricted countries. The travel ban simply does not apply to you in this capacity. Lawful permanent residents of the U.S. or green card holders are exempted from the travel restrictions, as affirmed by Frederickson and Byron legal analyses. This exemption is not an afterthought. It's explicitly outlined in the presidential proclamation itself and has been corroborated by numerous legal analysis sources, including major immigration law firms and various government agencies that specialize in these matters. That said, there's an important clarification needed regarding green card applications, which is a separate issue altogether from those who already possess one. The U.S. Citizenship and Immigration Services, or USCIS, in a memo released on Tuesday, announced that it would pause reviewing all pending applications for green cards, citizenship, or asylum from immigrants originating from 19 countries listed in a previous travel ban, as reported by NPR. This processing pause is distinctly different from any travel restriction. It specifically means that if you have applied for a green card and you are a national of one of these designated countries, your application has been placed on hold for additional review processes. This policy affects only pending applications and does not impact individuals who already hold their green cards, ensuring that current holders remain unaffected in their daily lives and travel plans. Furthermore, the December 2025 USCIS policy memorandum elaborates that applications from nationals of the restricted countries will undergo enhanced review processes, which could potentially include re-interviews, and there may even be re-reviews of previously approved applications for individuals from these countries who entered the U.S. on or after January 20, 2021. This added layer of scrutiny is designed to bolster security, but can lead to delays, so patience and preparation are key. Adding to this, while green card holders are exempt from the travel ban itself, there is one new requirement that applies to all non-U.S. citizens, including lawful permanent residents. Starting December 26, 2025, new biometric entry-exit requirements have gone into effect, meaning green card holders from certain countries may face enhanced screening and must now provide biometric data at every border crossing, as noted in VisaPix updates. This involves customs and border protection officers collecting biometric information such as photographs and fingerprints upon entry or exit from the United States. It's worth stressing that this is purely a documentation and screening requirement, not a prohibition on travel in any form. It's a broad security measure applied to non-citizens generally, though individuals from restricted countries might encounter additional scrutiny during the process. To make this all more tangible, let's break down what these policies mean for different groups of people in a clear and methodical way. If you are a current green card holder, you can absolutely continue to travel internationally and return to the United States without restriction. Just ensure that your green card is not expired. Carry documentation demonstrating your ties to the United States, and be ready for biometric collection at ports of entry. Your fundamental travel rights remain intact and protected under the law. For those applying for a green card who are from one of the 19 countries subject to the USCIS processing pause, your application is currently on hold awaiting further review. This doesn't equate to a denial, but it will likely extend processing times considerably. I recommend monitoring your case status through the USCIS portal regularly and consulting with an immigration attorney to explore your specific options and prepare for any next steps. If you are from one of the 39 countries subject to the travel ban and you're seeking to visit the United States or apply for an immigrant visa, new visa issuance has been suspended either fully or partially, depending on your country's classification. However, individuals from these impacted countries who currently hold valid visas may continue to use those visas for travel to the United States, as per PTOIC law, though obtaining new ones will be extremely challenging or impossible while the restrictions are in place. For dual nationals, there's a potential workaround. You may be able to circumvent the restrictions by traveling on a passport from a non-restricted country. For instance, a Haitian-French dual national entering the U.S. on their French passport would be exempted, according to employment law worldview analyses. This highlights the importance of understanding your citizenship status and passport options fully. Beyond green card holders, the proclamation outlines several other notable exemptions to ensure fairness in certain contexts. These include certain diplomats and government officials who are essential for international relations, athletes, and their support staff, participating in major events like the 2026 World Cup and the 2028 Olympics to maintain U.S. commitments to global sports, and certain special immigrant visa holders, such as U.S. government employees or ethnic and religious minorities from Iran, who are facing persecution and need protection. Additionally, there's a waiver process available, albeit limited in scope. The proclamation permits case-by-case waivers at the discretion of the Secretary of State when granting entry would serve a significant U.S. national interest. However, based on historical precedents, these waivers are anticipated to be rare and quite difficult to obtain, requiring strong evidence and often legal support to navigate successfully. Shifting to practical steps you can take based on these official policies, here's what I recommend depending on your individual situation to help you stay proactive and protected. For current green card holders, first and foremost, verify that your green card is not expired or nearing expiration. If it's set to expire within the next 6 months, file for a renewal immediately through USCIS to avoid any complications. Second, ensure that USCIS has your current address on file, as you are legally obligated to update your address within 10 days of any move. This keeps you in the loop for any important notifications. Third, when planning international travel, gather comprehensive documentation of your ties to the United States, such as recent tax returns, employment verification letters, property ownership documents, and details about your family connections here. This can help demonstrate your intent to return and maintain your residency. Fourth, prepare mentally and practically for potential delays and questioning at ports of entry, especially if your nationality is from one of the restricted countries. Always answer questions truthfully and calmly, remembering that as a lawful permanent resident, you have the unequivocal right to return to the United States. For individuals with pending green card applications, make it a habit to check the USCIS website and your personal case status frequently for any updates or requests. If your application falls under the processing pause, meticulously document all communications from USCIS and respond to any requests for additional information as promptly as possible to avoid further delays. It's highly advisable to consult with a qualified immigration attorney who can evaluate your unique case, provide tailored advice, and help you understand potential pathways forward. Do not jump to conclusions that your application is denied simply because it's on hold. Many such pauses are temporary and resolve with proper follow-up. For those outside the United States from affected countries, if you held a valid visa prior to January 1, 2026, rest assured that it remains valid and you should be able to use it for entry, though you might experience additional screening procedures at the border. If you're in need of a new visa and hail from one of the 39 restricted countries, be aware that visa issuance is currently suspended, so monitor official State Department guidance closely for any shifts in policy. Also, assess whether you qualify for any of the outlined exemption categories, and if you think a national interest waiver might apply to your situation, seek guidance from an immigration attorney on the application process to strengthen your case. To ensure you're basing your decisions on solid ground, it's absolutely critical that you verify all information from official sources rather than trusting social media posts, viral videos, or secondhand accounts that often distort the facts. Here are the most authoritative sources you should bookmark and check regularly. The White House official website at whitehouse.gov publishes the full text of presidential proclamations, including the December 16, 2025, one that's central to these changes. The State Department's Bureau of Consular Affairs at travel.state.gov offers up-to-date guidance on visa restrictions, travel bans, and related advisories. U.S. Citizenship and Immigration Services at uscis.gov posts policy memoranda, processing updates, and detailed guidance on benefit applications like green cards and citizenship. Customs and Border Protection at cbp.gov provides essential information about entry requirements and procedures at ports of entry, helping you prepare for what to expect. For deeper legal analysis and interpretation, reputable immigration law firms often publish alerts and guidance documents, while organizations like the American Immigration Lawyers Association offer valuable resources and tools for immigrants. Understanding the broader legal framework behind these policies can also empower you. The President derives authority to restrict entry under Section 212F of the Immigration and Nationality Act, which permits the suspension or restriction of entry for any class of aliens if their entry is deemed detrimental to U.S. interests, as explained on the White House site. This authority isn't new. It was utilized during the first Trump administration for similar travel restrictions, which faced legal challenges but were ultimately upheld by the Supreme Court after modifications during litigation. The current proclamation includes provisions for periodic government reviews every 180 days to evaluate whether the restrictions should continue, be modified, suspended, or supplemented, according to White House statements. This built-in review mechanism suggests that the list of countries and the specifics of restrictions could evolve over time, so staying vigilant is key. One particularly significant change in the December 2025 proclamation, compared to earlier travel bans, is the elimination of certain exemptions that previously protected family ties. Specifically, it removes prior exemptions from the June 2025 travel ban for immediate relatives, such as spouses, unmarried children under 21 years of age, and parents of U.S. citizens applying for immigrant visas, as noted by Fredrickson and Byron. This shift means that even if you are the spouse, minor child, or parent of a U.S. citizen, if you are a national of one of the restricted countries and outside the United States without a valid visa as of January 1, 2026, you will still be subject to the entry restrictions. This hardening of policy marks a departure from previous bans, which often carved out protections for immediate family members, potentially separating families and adding emotional strain to an already complex system. Now, addressing a common point of confusion, what the 90 days actually refers to in recent discussions. The USCIS agency mentioned in a Tuesday memo that within 90 days, it would create a prioritized list of immigrants for review and, if necessary, referral to immigration enforcement or other law enforcement agencies, as reported by PBS. This 90-day timeline strictly pertains to the timeframe USCIS has to develop that prioritized review list for pending applications from the restricted countries. It has absolutely no connection to a 90-day freeze on green card holder travel. The two issues are entirely separate, and the mix-up between them has unfortunately fueled unnecessary panic and anxiety in immigrant communities across the country. As a green card holder, it's vital to know your rights to navigate any interactions with authorities confidently. You have the right to return to the United States without undue interference. You are entitled to due process under the Constitution, meaning the government cannot arbitrarily revoke your status without following proper legal procedures. If you're questioned at a port of entry and an officer implies you've abandoned your permanent residence or pressures you to sign forms relinquishing your status, you have the right to request to speak with an attorney immediately. You also have the right to a hearing before an immigration judge if needed. Never sign any document you don't fully understand, and avoid making statements that could be misinterpreted without first consulting legal counsel. Support organizations such as the American Civil Liberties Union, the American Immigration Lawyers Association, and various legal aid groups frequently provide resources, helplines, and sometimes emergency assistance, especially during times of heightened immigration enforcement like now. Looking ahead, the immigration policy landscape in the United States continues to be in a state of flux, with the current administration signaling intentions to implement more restrictive measures across various categories. We've seen not only expanded travel bans, but also processing pauses for certain applications, increased vetting requirements, new biometric collection mandates, proposed revisions to the public charge rule that could make obtaining green cards more challenging, and dramatic reductions in refugee admissions. For anyone navigating the U.S. immigration system, whether as a green card holder, visa applicant, or someone pursuing permanent residence, the essential strategies remain consistent. Stay informed through verified official sources. Document every aspect of your interactions and applications. Understand and assert your rights. Seek qualified legal advice when uncertainties arise. And maintain flexibility in your personal and travel planning to adapt to changes. To summarize the key points we've covered today, there is no travel freeze imposed on green card holders. Lawful permanent residents are explicitly exempt from the travel restrictions that took effect on January 1, 2026, allowing you to continue traveling internationally and returning to the United States without issue. However, significant restrictions do affect nationals of 39 countries seeking new visas or entry into the United States. There's also a processing pause impacting pending applications from 19 countries for green cards, citizenship, and asylum claims. Additionally, new biometric requirements at all ports of entry apply to all non-citizens, including green card holders, as part of enhanced security protocols. The immigration environment is indeed complex and evolving rapidly, which is precisely why channels like this exist, to deliver accurate, verified information from official sources, empowering you to make well-informed decisions about your immigration status and future plans. Thank you for joining me on US Visa Info. If this update has helped clarify things for you, please like, share, and subscribe for more essential immigration insights. Stay informed, stay safe, and I'll see you in the next video.